Thank you so much for joining us yet again. I see many familiar faces, a few new faces, and in the interest of time, this is now a good time to start. My name is Wangare. I am the lead research mentor at AIDA Africa. AIDA Africa is an organization that exists to support emerging scholars and researchers from all fields, levels, and should I dare say also age groups. Our space is really from the budding student all the way to the retiring professor. All people from all different careers who are interested in the single universal language of research are welcome to join us. We have had some exciting news recently with now 4 journal club groups. Full WhatsApp group is 257 members. So if you do the math, we are now going to close to 1,000 members in the 4 groups. And we are really excited about that. As our numbers grow, we've also increased the diversity of research mentorship. And nowadays you will find a subgroup of your interest, or you could also create one. If you speak to Aurelia and have the group running in that way, you can organize members of the same field as you are for matters research, and we would like to go deeper and grow even bigger. Today we have a really special guest who is one of us, and I'm going to introduce her shortly. The topic today is Data Protection Act, Kenyan context. All our research mentorship sessions are such that they are highly interactive. So feel free at any time to type in the chat or raise your hand if you have a question, and we get to decide, the speaker gets to decide whether those questions can be at the end or as the program continues. We only have 1 hour and the clock is already ticking. So I'll go right on to the introduction. So our facilitator today is Thrity Engineer Mbuthia. She is a certified executive coach and professional marketer who has a passion for matters leadership. She is the first East African woman fellow of the Chartered Institute of Marketing, CIM UK, and currently is an adjunct faculty at Strathmore Business School. She is also pursuing a doctorate in philosophy in management and leadership at the Management University of Africa, MUA, with her research focused on leadership and millennials. Today, we unpack data protection and rights to personal information or privacy, compliance standards for researchers, data officers, and students in line with the global GDPR regulations and the Kenya Data Protection Act. So over to you, Thrity. You are welcome to begin your presentation.
Thank you so much, Wangari. Thank you for the opportunity to be with you today, and good evening to everyone on the call. I hope you can hear me well, because I can see the technology is telling me I have internet down. What do they call them? Some issues to do with speeds and things.
Right. So I can hear you loud and clear. I don't see any buffering. You're good to go.
Thank you for that confirmation. Right. So like Wangari has said, my name is Thrity Engineer. I know I usually get 2 questions around this time. The first one is, what do you mean engineer? Is that your profession? And most people kind of think that it is. That couldn't be further from the truth, because I'm actually a marketer that's my background. And the name engineer came about from one of the great grandfathers. Please don't ask me which great grandfather, but one of them was actually an engineer by profession, and then it got incorporated as the family name. And the second question I get asked is, are you Kenyan? So yes, I'm Kenyan. I was born, brought up in Mombasa, and here I am. I'm so happy to be sharing this topic with you today. Let me just pull up the slides and I'll tell you a little bit about how I got interested in this topic. So I had the opportunity to teach a class. I am also part of the adjuncts faculty at Strathmore Business School. And I had the opportunity to teach a class on corporate governance. And within the context of corporate governance came the issues to do with compliance and the issues to do with adherence to regulations. And this particular class happened to be a class that was focusing on IT. And of course, it sort of seemed to fit into the entire discussion. But when I started looking at it in detail, I realized that not only do individuals who are in that sector need to think about these changes, but so do marketers. And so I'm also on an agenda to talk more about how the data protection and privacy regulations impact marketers. But for today, I'm here to look at the context of research. I think it's just interesting as to how we can bring all this together and how context makes everything come alive. So without further ado, let me get started. And data protection. So let me ask you a question and you can just type in the chat. How many of you feel data protection is important? And how many of you feel it's not important? So if you feel it's important, put it in the chat. If you feel it's not important, put it in the chat. Okay, let's see what we get. Important. Do you feel it's important? Not important. Anne already has a question. Or is that your way of saying important? Surely, I'm not even expected.
Anne, you would like to speak? Welcome.
Let me guess, she says she means it's important. Hi, Anne. Okay, let me guess she meant it's important. My colleague from Strathmore is here, Njane, he says it's very important. Thomas says it's important. Relatively important, says Marco. Right, so at least we seem to be more on the side of important than not important. Data protection. Privacy usually is a word that invokes a lot of emotion. There's, you can see from the board there that the words that usually go with privacy have to do with information, data, policies, sometimes touching on things to do with secrets or protecting information. You also hear about the government, you hear about people. So there are lots of words in there. And of course, with the shift, the strong shift towards everything being online, the concept of data protection and privacy is definitely an issue that people are talking about today. So I'm sure you're all in different WhatsApp groups, and even if you didn't catch it on WhatsApp, you must have caught it on some form of social media, where we had an incident not too long ago where the Kenya Revenue Authority released a whole lot of information that had to do with PIN numbers and names. How do you feel about that? When you saw it, if you saw it, and if you didn't see it, you could imagine it, your PIN numbers up there for everyone to see, your names up there for everyone to see. Aside from the reputation or aside from that angle, how did you feel about this information being out here in the public domain? Were you happy? Were you annoyed? What was the emotion you felt? You can put it on the chat. If you didn't catch it, you could imagine that it's something that's happening, but it did happen. Uncomfortable, vulnerable. Marco says, if they want to pay my taxes, I'm happy for them to have my PIN. I think we would probably all agree. Exposed, yeah, you feel very uncomfortable. You're not too sure who's going to get hold of this information, what they can do with it. And the more information that is out there, the worse it probably feels. Yeah, you just feel extremely vulnerable and really not sure what's happening. So what is this Data Protection Act? So prior to 2019, there were lots of attempts by individuals to introduce some sort of regulation into this space to drive protection and privacy. I think the initial attempts started way back in 2012, but it took several years for this to be put into a bill and then an act. And so in 2019, the president actually signed it into law. I remember this because it was towards the end of 2019. And I said, finally, we have these regulations in place. And finally, we're going to see some sort of order coming through, okay? And so what did this Act of Parliament do? It established the Office of the Data Protection Commissioner, and this office is then responsible for the regulation of the processing of personal data, all right? It also then gives rights to those who own the data subjects, and it also then says what can and cannot be done by the data controllers and those who are processing the data. So we look at this Act of Parliament, and here we have the Office of the Data Protection Commissioner. Interestingly enough, the commissioner was only appointed, I think, at the earlier this year. That's her right there, Immaculate Kasait. And then the office itself sort of has been doing a lot of work to try and look at the act and then come up with regulations that operationalize the act. So currently, if you go to the website of the Data Protection Office, you will see that there are three regulations that are being discussed and shared by various stakeholders. There are the general regulations, there are those that touch on compliance and enforcement, and then there are those that guide on the registration of the data controllers or the people who are processing this data. So there's quite a bit of activity going on there. And just the fact that we're moving towards operationalizing it is sort of the right sign. If you've also noticed in the media, there's a lot of articles, there's a lot of information that's coming through about the Data Protection Act, just to increase knowledge and to sensitize more people about it. Because I think there's a lot of misunderstanding, there's not that clarity of knowledge in terms of what we can do, what we can't do. So this is the time when that all that is coming into place. The audit firm Grant Thornton decided to put together a video. So allow me to share. It's a very short clip, but I have to swap screens because I've not been able to download the video. And hold on a second. Right. So it's a very short clip. Now it doesn't automatically flip to my slide. So hold on a second, let's do it again. Here we go. All right, so when we are looking at this area of the Data Protection Act, you can see that there are several areas that it really tries to emphasize the aspect of privacy and the importance of privacy, the aspect of the individuals having specific rights. So you have the right to do a few things because the data actually belongs to you. And it just gives you more, should I say, more comfort that your data is actually being used in the right way, it's being protected, it's being stored, it's being taken care of in a manner that you would expect. So what are some of the principles that are captured within the Act? So the first one, and this is a direct lift from the Act, so that's why this slide is extremely wordy, but I wanted you to see it in its entirety so that you can think about how it impacts you in the context that you want to interpret it. So the first principle is that it's processed in accordance with the right to privacy of the data. That means that that data has to be secured, and secured in such a way that not anyone or everyone has access to that data, all right? Which means that if you're an organization that is holding data, personal data of individuals, you must ensure that that data is completely secure and that access to that data is highly restricted. So this would be very simple if you are a small organization. Maybe you have a list of 10 clients and you're collecting information about your clients. That would be fine, all right? It wouldn't be so difficult to do. But think of it in the context of if you were Safaricom and you have 30 million users of M-Pesa. And before you register for M-Pesa, you have to give out such a lot of personal information that the organization is going to hold. So think of it like that, or a bank, all right, where of course anything touching on money always ends up being quite a sensitive thing. So the right to privacy, the right to ensure that your data is protected is really key. And we hear a lot about data breaches. We hear about, often in the past, you've heard of cases where Yahoo comes and says, oh, email addresses of many of our users have been accessed. The passwords are out there somewhere on the dark web or things like that. So clearly, there's been a breach that has taken place and that data was not properly secured. The second says that there's the process of the principle of processing in a manner that is lawful, fair, and transparent. Okay. So what do we mean by transparent? It means that if I request you for data for a particular reason, I must be upfront and tell you what I need it for, okay? So say, for example, you're signing up with an insurance company, all right? And you want to insure maybe your house, right? And in the process of doing that, the insurance company is collecting some information. We may need someone to mute their mics. Let me see. All right.
Just muted his. Yeah, you may proceed.
Thank you. Thank you. All right. So what does the company then need to do in order to ensure that they are transparent? They need to actually tell you what that information is for. They need to tell you what they're going to use that information for. Okay. So whether it is to track you, whether it is simply to process your application, whether it is to get more information about you, whether it is to send you a whole load of other marketing information and say, all right, well, thank you for signing up for home insurance. By the way, we also have car insurance, we have health insurance, we also have mortgages that we've started giving out, you know, whatever it is. So when the request is made to collect that information, it must be fair and it must be transparent. And so we don't have a situation where I'm sure many of us have had this scenario where you have terms and conditions, in tiny print there, and you probably don't read them. And then when an issue arises, you're told, but it was already there in the terms and conditions. So that's not very transparent, because you're pushing the responsibility over to the customer, you're pushing over to the client. But in this case, what you need to do is to be upfront, honest about it right from the start. The next thing is that the data is collected for explicit, specified, legitimate purposes, and not processed in any manner that is incompatible for this kind of processes. So what do we mean? If you're collecting information, or say, for example, you've asked people to register for a webinar, okay? And it's a perfectly legitimate request, register for the webinar, so that then I can send you the link. I can make sure that the people who are on the webinar are actually the people who need to be there. It's very, very legitimate, okay? But now what happens is that the organizer of the webinar has a list of email addresses. They have contacts of names and maybe even phone numbers, right? So 2 weeks later, they decide, oh, you know what, by the way, I went and did some farming over the weekend. I harvested some oranges, and I think I need people to buy these oranges. So how about I send out this communication to all these guys who came and registered for the webinar, okay? But the problem here is that that was not the purpose that you used or rather you requested the collection of this information, okay? And that ties in with point D, which says that it is limited to what is necessary. No, let me just try to explain the third one first. So legitimate purpose, what did you collect the information for? And can you use it just for that purpose, not for any other purpose, all right? So I have no right to send you information about oranges when you only registered for the webinar, and that was the only reason you gave me that information. I should not breach your privacy by then deciding that you are a potential market for me to sell oranges. It might sound like a very simple example, but when you see how to implement the exact same principle in other scenarios, you'll see that actually there's quite a bit of breaching of this that happens. If you're in a WhatsApp group and suddenly someone decides they want to send a message to everyone who's on that WhatsApp group, they're using it like a database that has been set up. And that information, then they want to maybe fundraise for someone, or it goes completely outside of the reason why that particular WhatsApp group was formed or was set up. Okay, so use the data that you collect for the purpose that you have specified and not for any other purpose. In the event that you want to use it for another purpose, you need to ask for permission. So if I want to sell you oranges, I should actually come and ask you for permission to send you more information on oranges. And if you agree, that is fine. And if you choose not to accept that, that is also fine, and I should respect that, okay? Part D says that it is limited to whatever is necessary in relation to the purposes of what is processed. So what we mean here is that you do not need to collect more data than is necessary. So if you're registering for a webinar, for example, then you do not need information on my ID number, or you don't need information on where I live. Yes, but if you're registering for a bank account, perhaps that would be something that would be important for the bank, because they have a process in place, know your customer. They want this information to ensure that the money that is passing through their institution is, it's not any money laundering or anything of that sort. So it's pick or request for information only what is necessary. And I've heard of a lot of people complaining that when they're registering for things, there's too much information that is being asked for. So when you're being asked for your mother's maiden name, now what relevance has that got to do if you are signing up for a course? at a university. All right. So only ask for information that is necessary and limited to the purpose you require it as you process it. Okay. Then E says it's collected only where a valid explanation is provided, whenever information relating to family or private affairs is required. So provide an explanation. Don't just ask for information and demand that you should be given personal identifier information. You provide an explanation as to why it needs to be processed. Why do I need your physical location? Why do I need information on your age or your birth date, for example? Okay. F says that this is the principle of accuracy. Information must be kept up to date. So when information is not kept up to date, there's of course the danger that the information is incorrect, but there's also the danger that if the person who's processing the data is trying to get in touch with you or trying to use that information to verify that it's you, then that information is inaccurate and makes it quite hard.
Kindly mute yourself. Yeah, please proceed.
Thank you. So accuracy is key, and you should be able to request. It is within your rights to request that if the data that has been captured is not accurate, then you have a right to request for that data to be updated. Okay, so say for example, you signed up with a bank, you gave out a particular phone number, maybe that phone number is no longer valid, you have a new phone number, and you want that information to be updated, you want the records to be updated, you have a right to request for that information to be updated. And that should be rectified without delays, making it inconvenient for you, because this personal data actually belongs to you. It's your data, all right? Then G, this is the principle that says that data must be kept in a form which identifies data subjects for no longer than necessary. Okay, so data that is collected, there's different aspects of data, different bits of information, and this data actually identifies an individual. This means that if there's a breach, someone can identify this individual using these bits of information. Okay, so it must only be stored for as much time as actually is required. For example, if you buy a car, all right, and you're happy you have a new car, you're registering it, the dealership is giving you information about the car. They say, oh, fill in all these details. We'll call you when the service is due. We'll call you when the first 1,000 kilometers is done, and so on and so forth. All right. Now, say for example, you decide you do not want your car to be serviced at that dealership, and you found somebody else to do the job for you. How long should that dealership hold on to your data? How long should they hold on to your ID number or your PIN or your KRA PIN number or anything like that? Should it be 6 months? Should it be 1 year? Should it be 7 years? All right. Why do they need to hold on to that data for 2 years if you haven't actually stayed their customer? So the next question would be then, well, how long should we hold on to data? And this question is determined by your organization, by the sector you're in, and the purpose for which that data was collected. For example, if you're a bank, perhaps you are asked or required by law to keep records of these individuals who are your customers. So if they're your current customer, maybe you're supposed to keep records for a certain duration of time. But if they stopped being your customer, what happens? Do they still have to keep all your information forever and ever? Probably not. So each organization would look at a policy, would look at the regulations, would look at the requirements, and then say, how long do I need to hold on to this data? Because if anyone accesses this information, they're able to identify this particular person. So that's important for us to think through in terms of how long do you want to stay with that data. And then finally, the last principle is that it's not transferred outside the country unless there's proof of adequate data protection. and or consent from the data subject. So that means that people should not be able to lift your data and then pass it on to anywhere or any other person or any other organization they feel like, unless you have actually given consent. So what is the scope of this act? And I'm bringing this in because I want us to think about how it impacts us. Most of us feel like, oh, well, data protection or data, that probably refers to organizations that process huge amounts of data. But it's actually not true. It's anyone who is in the process of entering into a record. Yeah, you can see from the first point there that anytime you record personal data, right, whether it is in an automated system or it is in a non-automated system. So even if you have a book and you write down all the names of your clients and you write down their phone numbers and you write down their email addresses, that still counts as you processing personal information. So if you're a researcher, you're a consultant, and you decide to do it the good old-fashioned way, that still counts. If you open an Excel spreadsheet and you're using an automated process, it still counts, okay? But this is what is more interesting, the second point. This act applies to processing of personal data when this data is processed by someone who is established or resident in Kenya and processes personal data while in Kenya. So it's not about who's a citizen or not a citizen, it's about who's resident in the country. You process that information while you're here. The second scenario that is being presented in the act says that this still applies to someone who is established or ordinarily a resident, not established or not ordinarily a resident in Kenya, but is processing personal data of data subjects located in Kenya. So if there's an organization sitting out there outside of Kenya and they're holding data for individuals who are located in the country, then they're still responsible for adhering to the basic principles or the respect for data protection and data privacy. Okay, so what kind of scenario would that mean? Perhaps it's a multinational organization, doesn't have a presence in Kenya, but they have employees. So they will be processing information for their employees, or they have suppliers, they'll be processing information about their suppliers, or organizations that are actually getting materials, raw materials, or imports. Not, well, depends on how you look at it. If they're sitting out there outside of the country, then they would be importing, we would be exporting, right? So if they're collecting information for all those who are supplying the raw materials out of Kenya, and they're sitting maybe in Germany or any other country, then they would be required to adhere to some of these principles, not some, but all the principles that we're talking about. So it's interesting how the scope doesn't mean that just because you're not in the country that you're not hit by this. Now, we've talked about personal information, but personal information could relate to things like your name, your address, your email, your age. So anything that allows an organization to, anything that allows someone to identify who you are based on the information they collect. But then we have what is called sensitive personal data. And this really gets to the heart of it, where it adds to the information about you and really requires some level of privacy around it. So for example, anything to do with your race, anything to do with your health, anything to do with your ethnic social origin, your beliefs, biometric data, your marital status. It's just information that is very, very personal to you and rather sensitive, because one would not want this kind of information out there in the public domain, and certainly not if there was a breach, okay? So this becomes even more important and more keen for us to think about. As researchers, are we collecting such kind of information? Do we actually need to collect this information? Remember, we said we only collect information for the purpose that is required and limited to the amount of time that we require to have it with us. Some of you may be familiar with this term called GDPR. So this stands for the General Data Protection Regulation. Data Protection Regulation is the toughest privacy and security law in the world. It has been set up in the European Union, and it came into effect in 2018. So they started talking about it in 2016. And unlike us who sort of struggled to get these regulations in place, they did have regulations prior to this, but they decided to amend them and build them into a much more robust framework. And so they came into effect in 2018. And if you can remember, or if you may recall, around about that time, many people received a flurry of emails saying, do you wish to continue receiving communication from us? We're asking for permission on this, that, and the other. And so that was just organizations that were trying to adhere to these regulations, because they were given up to that time. They were given, it started in 2016, but they were given the 2-year grace period by which time they must be fully compliant. So by 2018, they were required to be completely compliant to this. Now, why have I put this here? Because I want you to look at the second point, which is that GDPR imposes obligations onto organizations anywhere. All right. Remember, we've just said it's the toughest security and privacy law in the world. It imposes obligations onto organizations anywhere, so long as they target or collect data related to people in the European Union. Which means that sitting in Kenya here, if you have an organization that has shareholders, and those shareholders are sitting in any country in the European Union, and you are holding data that belongs to those individuals, you are required to adhere to that set of regulations, failure to which it is possible for them to levy fines, and those fines are actually quite heavy. All right, and you can see they said tens of millions of euros. Sometimes they look at the turnover of your business, and you can find yourself literally wiped out simply because you didn't adhere to these regulations. So I find this quite fascinating. And actually, as you can see from the timelines, this came into effect in 2018. The Kenya Data Protection Act came into effect in 2019. There is a lot, if you compare the two, there's a lot that the Kenya Data Protection Act has borrowed from the GDPR regulations. Yeah. And so what happens is just the fact that, and I really found this, fascinating, that usually one thinks of the law as what is available in that particular country, impacting people in that particular region. But this really stretched it, and said, no matter where you are in the world, as long as you're getting hold of information that belongs to people in the European Union, you are actually expected to adhere to the GDPR regulations and principles. Yeah. So there's a very interesting video clip, which I will not play because it's rather long, it's 7 minutes, but I know the slides will be shared and you can take a look at what GDPR says. And the aspects or the principles are very, very similar. They look pretty similar, and they also outline things to do with the rights of the data subjects. Yeah, so remember that at the end of the day, the data belongs to the subject, and that subject is you. So that data does not belong to the organization that's processing it or storing it. It belongs to you. That is your data. And so it's very important that you take up the, can I say, the responsibility for being responsible. Gosh, that's a terrible sentence, but yeah, just being aware that that data belongs to you, and so you have a right to certain things when that data is being processed. So an organization is responsible for creating awareness within internally and also externally, all right? And you're seeing a lot of organizations now coming up and saying, this is our data privacy policy. You're seeing it being put out even on websites, for example, where you're being told about cookies, for example, and you're told this site collects cookies. What do you give consent to? Do you allow us to collect information? Because that's also another way that you can be traced or tracked. Yeah, because every time you log in, your machine has a certain IP address through your service provider, and you can be identified as this particular machine or this particular individual who's accessing this information. So websites now have taken to actually asking you, what do you allow us to collect about you? Do you allow us to collect just the basic information? Do you allow us to collect more than that? Do you allow us to send you marketing messages? So what they're doing is that they're going to the third point, which is saying that they're asking for your consent. They're asking for your consent and involving you in the process of making the decisions. So they're giving the control to you and not just assuming that that data, they can do whatever they like with it. Okay, so anytime that data is being collected, processed, recorded, consent is being requested for. Okay, and that goes over and beyond say websites. It also is within email marketing. So can I send you information on email on say, for example, my organization is selling tractors. I send you information on tractors, but if I then need to send you information on a different set of machines, maybe I have trucks, then I need to ask you whether I can do that. So are you giving me permission for me to send you this information? Or do you ask for a blanket consent and say the consent that I'm requesting for is any marketing communication that stems from this organization? Okay, but you're actually seeing what is happening is that we're seeing organizations that are going into details of what it is they're asking consent for. And so you see organizations saying they will never sell your information, or they will never share it with third parties. That is just to emphasize and reinforce their aspect of building credibility with their customers by saying, we will not go this way. So we are respectful of your privacy, and therefore we will only use the information you've given us for the purpose that you have allowed us. All right. So if you have a customer management system in place, usually they're referred to as CRMs, customer relationship management systems, and that information is being collected, again, consent is required before someone is actually entered into the system, right? It's also the responsibility of the organization to understand the whole concept of privacy, how customers are profiled, what kind of data is being collected, and how much extra data or data augmentation that is required. And the point here is that the aspect of privacy has to be put in prior, not after. So as you are creating these databases, as you are creating these management systems, as you are making the upfront request for the information, you need to factor in the aspect of privacy from the beginning. And of course, organizations are struggling with this because they already hold information, and now they're moving more to compliance rather than looking at the design, which is fine because that's where we start. We all need to start somewhere. But there'll be the aspect of them thinking about it right from the beginning in terms of the designing of the collection of this kind of information. And then it's also important for an organization to have that upfront and transparent information on privacy notices. So you will see this coming up, whether it's, for example, you might have a portal that your organization is involved in. it's a portal maybe for suppliers or a portal for customers to log in and be able to place their orders, or whatever it is, and you find that the privacy notices are now being posted upfront, so that you can actually see what information is being collected, how it's being used, and there's a lot of transparency that is coming about from that. Okay, so time for a question. What's the one thing that you've picked from our discussion so far on this area of data protection and privacy? You can put it on the chat. One thing that you've picked, you found it interesting, you found it, you found it struck you in a certain way. Just one thing that you picked up from our discussion. Anyone? Put it on the chat. 1 point, just one.
I believe we are all digesting the very detailed and thorough presentation. Thank you so much, Thrity. I've learned a lot, and I must say, I have enjoyed the presentation. And I see we have a question from Kihinda. Do organizations and researchers need to register with Data Commission before they collect data?
I think that's an interesting question, and I would answer your question in 2 ways. One, there's already a process in place for researchers to go through a review. I'm sure Wangari can give us a lot more detail about that. So that would be a sort of like a different process, more to do with research than anything else. In terms of organizations that are commercial entities or even non-profit organizations, there is a process in place that is being rolled out. So you may have seen again in the media that there's a sort of like a requirement, something to do with the number of employees you have and the turnover of your business and what your business is involved in. And if that's the case, then there's sort of like a table. You can look at the table. I think it's also available on the website for the Office of Data Commissioner. And therefore it will soon be a requirement that organizations that actually store data and process data have to be registered. Remember, there's also a requirement that organizations that have a certain amount of data need to have a data officer in place. So this data officer's responsibility is to ensure that there's adherence to all the requirements as per the regulations. Yeah. So I hope that answers your question. And John says that he's learned not to ask for more than you require. That's absolutely true. You've learned about the intersection between GDPR and Kenya Data Protection Law. Yeah, that one I actually found quite interesting, and of course, you know, because of historical reasons, we tend to borrow a lot from that side of the world. But you must admit that it really does tend to protect the data subject at all costs. And so if we are removing ourselves from the equation and thinking of ourselves as data subjects, you would really want to feel much more confident that that data that you're providing is actually something that is being taken care of in the best way possible. So finally, before we close, how does this impact you as a researcher? So of course, the first thing is to be aware of the Data Protection Act so that you can know what to ask for, what kind of information you need to ask for. You need to think through how long you're going to store that information, if at all you're going to do that. Of course, the other way that as researchers, we sort of think about anonymizing a lot of the data. So there's that we could also take up, and by doing that, or just by allowing people to respond to our research questions in an anonymous fashion might certainly help the process here. because that way you'll be collecting very little personal identifier information, you know. So if you put it all together, you'd not be able to identify who this individual is, you know, just saying this is you're female, your age between 18 and 20, you know, it could be anyone in the country, yeah. But when you get into the details of things that identify the data subject, now that's where we need to think around that. Then review how you collect your information, and more importantly, how you store this information. So if you do collect personal identifier information, be careful about how you store it, those who can access the information, those who can access the files. If you have backup, for example, try to see whether you can secure it in a way that not anyone or everyone can have access to it. Be transparent when you're asking for the information, be clear up front. Unambiguous consent is key. So what do I mean by this? You may have had instances where you're being asked whether you agree or you don't agree. And you get this little checkbox at the bottom and it's already checked for you. So you're not too sure, it's already checked. Does it mean that I already agree, or does it mean that I don't agree, or does it mean I should undo the tick mark? You know, it's kind of all confusing. So what this is saying is, don't make it confusing. Make it very, very clear, very simple. If you tick this box, you have given consent for 1, 2, 3. So it's unambiguous and everybody is on the same page. No one comes back and says, I didn't understand it like that, or this is how I thought you meant. So even those tick boxes, you can see that now they are not being ticked. It is for you to comment and actually put the tick in so that you give your consent. Most importantly, remember that personal identifiable data does not belong to you as a researcher. It belongs to the data subject. And so respect it and give it the due consideration. I'm sure you would also love someone to do the same if that was your data. There are more questions that are coming through. Let's see. Now that every organization needs a data officer, does this give us the unique opportunity to train data officers or even have courses in data and other related matters? It's a very good question. I think the requirement for having the data officer will only come, if I can remember correctly, at a certain at a certain level of the amount of data that your organization is processing. So for example, Safaricom already has in place a data officer. You can understand why they would want to have one person dedicated for the purpose of that. So yes, I think you're right. There is an opportunity to train people in this area, and definitely they would need to know a lot about how to protect it, how to secure it, how to do audits, and such like things. So definitely there's something there. Here we have another one. In the increasingly datafied world, data protection is vital to involve the risk of litigation. What's the risk of being sued if you indicate the wrong phone number at the entrance of a government building, such as in a visitor's book? And where does all that data go? Your guess is as good as mine as far as where that data goes. But you can clearly see that that data needs to be secured. That data needs to be put into a place where it is only accessed by certain individuals. That data should only be stored for a certain duration of time. So 3 months down the line, 6 months down the line, whatever the policy is of the security agents who are manning those particular buildings, there should be something in place, yeah? And for sure, the reason why people give out the wrong numbers, of course, is because you're not comfortable about who has access to this information and what they can end up doing with it, yeah? So I don't know whether you can actually be sued, you know, for that, but it's certainly something that people are going to have to think around in terms of, if you ask the question, what do you do with this information? I'm giving you this information, but what do you do with it? How do you store it? Then the organization that's collecting that information should be transparent enough to tell you exactly what is happening. I think sometimes maybe we don't know what our rights are, or maybe the organization that's collecting the data also doesn't know that that data, the data subject has a right to ask that question without necessarily breaching any security matters. Yeah. Yes. Should I continue?
Yes, we have 5 minutes to the top of the hour. So yes, you can take the last few questions as we finish.
All right. Most website cookies have a select all, or is it optional always? So what I've seen happening now is that websites are actually giving you the opportunity to choose what kind of information is being tracked about you. So there's the basic mandatory information, then there is information that's additional to that, and then there's information that they collect for marketing purposes. So it's, again, a slow process that I've seen happening, and basically what is going on is that they're giving you the option to choose, unlike those websites that either say, if you don't accept our terms and conditions, you can't use our information. So people are moving away from those kind of scenarios and giving more options, yeah, in terms of what you can and cannot do. And you've seen what is happening, say, for example, to WhatsApp. A couple of months back, they came with their regulations and said, you must accept our terms and conditions, otherwise you will not be able to use WhatsApp. But if you read the stories, you will see that they were not able to do that in the EU. For countries or users who are registered in the EU, they were not able to do that. Why? Because they had these stringent GDPR regulations in place. And our regulations are not always that stringent, or maybe the application is not that stringent. And so they get away with some of these things in terms of tracking and collecting data. But again, if you see what's happening to WhatsApp in a country like India, India just told them, no, you will not be accessing this information. And now there's a whole tug of war going on between them and the government of India, where they're trying to figure out which is the middle ground there. Yeah. So you can see there's a lot that is shifting even in the international space. Some of it might not be very clear. Some of it people might be trying to find their feet around there. So I'm sure clarity will come as we go along. Yeah. There's a comment here: what is not written down does not exist in reality. Do e-signatures hold the same weight as handwritten ones? I think this is more of a question for a person who has a legal background. But what I do know is that organizations are now becoming much more accepting of e-signatures, provided you use certain applications and you don't do it the old-fashioned way of just taking your signature and copying and pasting it onto a document. So I think there's a way in which your e-signature can be accepted. But I'm still seeing a reluctance from organizations to move to this direction. And so I think there will be a lot of change, primarily pushed by the COVID-19 situation. And there will be change. There has to be change. I mean, I don't think we have an option. I don't know whether we're ever going to go back to where we were before the pandemic broke out. So I'm still seeing a lot of stuff happening in this space, but I think a legal person would probably be able to advise more in terms of what happens if you sign a document. Do you have to sign it and scan it, or can you use an app that allows you to generate an e-signature? Yeah.
Thank you so much. Can we, with your kind permission, get your contact following all the data protection laws? On a light note, how can we reach you? A lot of people are asking that. And
all right. So my number's there, my email's there. You can reach me on info@thrityengineer.org. Watch out for the autocorrect. It loves to misspell my name. But we can also connect on LinkedIn. So you'll find me there as Thrity Engineer Mbuthia. Or if you want to try out technology, you can just use your phone right now. Use the scanner on the QR code, and it should take you directly to my LinkedIn page, and we can connect. I would love to hear from you. You can share what you thought about today's topic. And yeah, let's talk some more.
Thank you so much, everyone, for your time and for being here. And we appreciate you, Thrity, for taking time to really take us through this wonderful presentation. So from me to you all, it is good night and good evening from Nairobi. Thank you.
Thank you very much. That was really good.
Thank you.
All right. Have a wonderful time and we'll see you. If you're not yet a member of Journal Club, feel free to join us. I'm going to share the links to do that as soon as I can. Aurelia, could you kindly take over? All right, I think I got it. I got the links just in case we have a guest, although I see many familiar faces today. That's the link. All right, everyone. I think we can end the call now. Bye.
Thanks so much, Wangari.
Okay.
Much appreciated. Thanks, everyone. Have a lovely weekend.
You too.